Overwhelming student loan debt is a growing financial crisis. In Canada, student debt can be forgiven through the Bankruptcy and Insolvency Act, but there are some special rules. I'm Doug Hoyes, a licensed insolvency trustee with Hoyes, Michalos & Associates. Today I'm going to explain the 7-year rule for student loan debt in a bankruptcy or consumer proposal. When you borrowed money to attend school, you most likely applied for a loan through a government program like Canada Student Loans or a provincial program like OSAP here in Ontario. Government student loans can be forgiven in a bankruptcy or consumer proposal in Canada, but you must be past the legal waiting period. That waiting period is 7 years. Specifically, Section 178 Sub 1 Sub G of the Bankruptcy and Insolvency Act says that government-guaranteed student loans will only be automatically discharged in a bankruptcy if it has been more than 7 years since you ceased to be a student. But what does cease to be a student mean? When does the clock start? When you got the loan doesn't matter. The important date is when you cease to be a student, which is often the end of the month when you had your last exam or when you graduated or otherwise left school. If you went back to school after you graduated, that may reset the clock. Or not. The rules are somewhat complicated in this area. If you're considering filing a bankruptcy or consumer proposal and have student debt, it's important that you confirm your official end of study date for government student loan debt. We'll explain how to do that when you come in for your initial consultation, but basically it involves contacting both the federal and provincial student loan lenders and asking them to send you a letter confirming your end of study date. It's critical that you know what end of study date the government has in their system before you decide whether or not to file a bankruptcy or consumer proposal. Now, you may have noticed that up until this point I've been talking about government-guaranteed student loans. Many students take out additional private loans when going to school. This is very common in some professional programs. You may have an unsecured loan or line of credit from a bank or credit union. You may have gotten a credit card while you were still a student and still carry a balance. There is no waiting period to discharge private student debt in a bankruptcy or proposal. These debts are forgiven just like any other unsecured debt. Rules around bankruptcy and student debt can be complicated. If you have student debt, talk to your licensed insolvency trustee about the 7-year rule and any other concerns so you know exactly how your student loans will be treated before filing. You can also visit hoyes.com and look up student debt and bankruptcy for more information.